Good afternoon, everyone. My name is David Wilkins. I am the faculty director at the Center on the Legal Profession at Harvard Law School. And I want to welcome the more than 2,000 attendees we have at this very timely discussion about online courts. The Center on the Legal Profession is a research-based organization at Harvard Law School in which our goal is to do world-class empirical research on the profession, to improve how we teach and prepare not just law students, but professionals, and most of all, to act as a bridge or a facilitator for important discussions about our profession and the changes that are happening. We'll send you all information about the center, but I just want to say there really is no more important discussion we as lawyers could be having today than the one we're about to have about the future of online courts. We are so fortunate to have with us two amazing leaders, thought leaders on this issue. Professor Richard Susskind, who I'll just introduce briefly in a moment, many of you know has been a thought leader on all kinds of things around the profession and has just written a very timely book, which was even more timely than he anticipated, on online courts and the future of justice, which he'll tell us about in a minute. And then my dear friend and former law school classmate, Chief Justice Ralph Gants, the Chief Justice of the Supreme Judicial Court in Massachusetts, has been a leader in thinking about the future of justice and access to justice, and has been thrust into the position of how to take an entire court system online. After Professor Susskind speaks, Chief Justice Gants will give some remarks, and then we really want to have, as much as we possibly can, a conversation with all of you. We're very fortunate among our incredible participants here today. We have three leaders who have agreed to ask opening questions. Judy Perry Martinez, who is the current president of the American Bar Association, Justice Chandrachud, who is the current Chief Justice of the Indian Supreme Court, and Rochael Soper Adranly, who is a partner and chief legal officer at IDEO, which many of you know is the world's leading design thinking firm, and who has been thinking very seriously and critically about the redesign of our justice system even before this current emergency. After that, we hope to have time for questions from participants, and we urge all of you, as the webinar is going on, to use the Q&A function to ask questions, which we will then collect and try to offer some broad themes that come through in the questions to the participants. Our formal webinar ends at 1 p.m., but our participants have very graciously agreed to stay for another 30 minutes or so until 1:30 p.m. Eastern Time, to answer some of these questions and to continue the dialogue. So for those of you who can stay, we urge you to stay, because it'll be a very rich discussion. Just some quick housekeeping things. This book talk and the webinar is being recorded, and we're going to post this on the Center on the Legal Professions website. So for those people who weren't able to join us today, you'll have a chance to come back to it. We think it'll be a very rich and important resource. As I said, we'll be sending out some information to all of you, including about the center, but also bios and other information about our terrific speakers, so that we don't have to take the time today to talk about that. All participants will be muted and their videos will be off, because with 2,000 people, we couldn't put all the little Brady Bunch boxes on the screen. But we do, as I say, if you use the Q&A function, we'll be able to try to incorporate your voices into this discussion. We hope this will be the beginning of a dialogue with all of you, and we have people from all around the world, many judges, many policymakers, many academics, many leading lawyers from countries all around the world, and this is exactly the kind of discussion that we need to be having. So without further ado, I want to introduce our principal speaker, Professor Richard Susskind. He really is a man who needs no introduction. I will just say, for those of you who haven't been familiar with his work, please look up the kinds of books that he's been writing about the legal profession and its future, making predictions that many times have come to pass. He wrote this book before he knew about the crisis, but he's been thinking deeply about what the crisis means for this, and he's agreed to share some observations with us. So with that, let me turn it over to Richard.
Very much. David, many thanks for that introduction. Chief Justice Gants, thank you for joining us. Ladies and gentlemen, everyone who's listening in and watching, I hope you are as well as you can be, as healthy as you can be under these very disconcerting, difficult circumstances. We're here to talk about online courts, and the fundamental question that I ask in my book is this: is court a service or a place? Do we really need physically to congregate together to sort our legal differences? Or might there be other ways that we can actually resolve legal disputes? My book answers that question, and it won't surprise those who know my work to say that I say we can actually use technology to allow us to resolve disputes in quite different ways. But as David pointed out, I could not have been aware as I was writing this book of the coming tragedy of the COVID crisis. And so the question, is court a service or a place? I think most people would answer it very differently over the last few weeks as compared to the last few years. But what I want to do is track through the main arguments of my book, say a little bit about how they need to be updated. I suppose it's in a sense giving you forewarning of the second edition of my book in light of the COVID crisis, and then speak a little about access to justice as a global problem. The problem I was trying to address in the book is quite easily summarized. It transpires, according to OECD figures, that only 46% of human beings on our planet live under the protection of the law and have access to the courts. That seems to me to be deeply unsatisfactory. In some courtrooms around our world, we have staggering backlogs, about 80 million in the courts of Brazil, 30 million in the courts of India. And even in the most advanced systems, most civil disputes, for example, cost too much, they take too long, the process is unintelligible unless you're a lawyer, and somehow the whole thing seems, at least to me, out of step in a digital society. I go back to 1926, almost 100 years ago, to the words of Judge Learned Hand, who said, "As a litigant, I should dread a lawsuit beyond almost anything short of sickness and death." And I'm not sure judges today would say any differently. For all of this, though, as I try to agonize over how we might set up our dispute resolution systems differently, I often recall the story, and again, those of you who know me will have heard me relate this many times, about Black & Decker, one of the world's leading manufacturers of power tools, who apparently, when they recruit new executives, take them off on a course, sit them down in a room and put up a slide of a gleaming power drill. And they say to the assembled executives, "This is what we sell, isn't it?" And the new executives look rather perplexed by this. They say, "Of course that's what we sell. We're Black & Decker. We're the world's leading manufacturers of power tools." The trainers, with some satisfaction, say, "That's not actually what we sell, because that's not really what our customers want. This is what they want," they say with a flourish. And up comes an image, a photograph of a hole neatly drilled in a piece of wood. This is what our customers actually want. And it's your job to find ever more competitive, imaginative, creative ways of giving our customers what they want. And so I thought we should have the same mindset in thinking about the future of our court system, not to regard or use as our starting point the current power drill. How can we make it a bit, metaphorically speaking, cheaper, better, quicker? But how can we actually, first of all, identify what the hole in the wall is and perhaps deliver that hole in a different way? And the way in which we could deliver it, I argue, is through technology. But I want you to be aware when you're thinking of technology that there's two quite different sorts of applications of technology. The first is what I call automation, and the second is transformation. Automation is what many people have in mind when they think of technology. You think of some kind of inefficient process or activity, and you apply technology to it, you systematize it, you digitize it, you take some of the cost out of it. You don't fundamentally change it in automating it. In essence, this really is grafting technologies onto old ways of working. And the first 50 years of legal technology, of court technology, have been precisely this. using technology to streamline and optimize a system that was in some ways perceived to be inefficient. What is far more exciting about technology is transformation, though, in contrast. Not using technologies to support and sustain our old ways of working, but using technologies to allow us to do things that previously weren't possible. And that's what drove me in writing the book. I was thinking, how can we use technology to allow us to deliver outcomes that court users want in ways that weren't possible, for example, before the advent of the World Wide Web or the internet. And this took me, therefore, to online courts. And the web is all important because we wouldn't be having this discussion in 1990, before the invention of the World Wide Web. There wasn't an infrastructure, a platform upon which online courts could be mounted at that stage. But since then, there's been a thriving ODR, online dispute resolution community, thinking about how disputes might be resolved across the web, across the internet, and often referring, the best case study perhaps of all, to eBay. On eBay every year, amazingly, there are 60 million disputes, 60 million amongst traders, almost none of them sorted out by conventional lawyers in courtrooms, sorted out by a negotiation and then an adjudication process, a form of ODR, online dispute resolution. So I was asked in 2014 in England and Wales by our Civil Justice Council, which is an advisory body that advises the government and the judiciary on modernisation, if I'd look into the possibility, put together a team to examine the possibility of using online dispute resolution to sort out low-value disputes, low-value civil disputes in our system. And I assembled this team and we worked on it, but quite quickly we came to a conclusion that I think was important. I think most people who'd instructed us were expecting us to say, here are some of the cases we can take out of the court system and resolve them through some kind of private sector online dispute resolution, a kind of electronic ADR. But we came up with a different solution. We said, if these technologies are effective for the resolution of disputes, they should surely be used within the court system rather than, as it were, transferred out into the private sector. It's important that our court system is relevant, effective, is used regularly. So we came up with this idea of online courts. I've now extended the thinking in the book, and really, for the first generation of online courts, there's two fundamental components. One is what I call online judging, and the second is what I call the extended court. Online judging, in the first generation, is very straightforward. This is the idea that human judges decide cases not in oral hearings or in physical courtrooms, but on the basis of evidence and arguments submitted to them electronically, to which they respond in kind. They receive the documents, the parties dispute with one another or engage with one another electronically. There's no hearing. This is all done, to simplify, as an exchange of emails, as it were, and on the basis of the attachments as to the evidence, the judge comes to a decision and conveys that decision again by some form of electronic message. Online judging, not a radical idea, and in those justice systems where we have paper hearings, the decisions made on the basis of papers alone, this is not an entirely new concept. But we argued, and I continue to argue, for low-value civil cases, this might be a more sensible, proportionate, fairer way of actually resolving many disputes. But I don't want to stop there, as many people do. I think we should, in the digital age, be more ambitious for the service that a public court system delivers. The primary service, of course, is binding authoritative decisions by judges. But I want to argue that we should extend the function of the courts too. Because in an era when, frankly, very few people can actually afford access to legal help, so many people are representing themselves or just staying away from the system because the whole thing looks too forbidding. So it seemed to me in 2020s, we can surely have courts that do more than the primary function of making decisions. We can surely have systems online that can help parties understand their rights and obligations, to help them understand the options available to them, to help them marshal their arguments and organize their evidence, to provide to them non-judicial ways of settling the disputes, not as an alternative court system, but as part of the court system. And that's the idea of the extended court. So if you take these two concepts together, in a nutshell, what I'm saying in the book, and I'm focusing mainly, but not exclusively, on low-value disputes, it's a simplified public court service, not a private sector venture, it's a public court service, using online techniques as an integral part of the system, not grafting technology onto the old system, but providing an affordable, quick, intelligible, intuitive way of resolving disputes for people who can use technology. Enabling, therefore, non-lawyers to conduct their own cases, providing them with tools to help them assess and formulate their claims, allowing them to submit evidence and arguments online. But in the first instance, I'm arguing judges don't see these cases. They're handled, the cases, by case officers, who are individuals who can perhaps, by knocking heads together in an informal form of online ADR, help parties come to some judicial or non-judicial settlement. But if the case cannot indeed be sorted at that level, the case would be handed to the judge. But it becomes, in technical jargon, an asynchronous process. A synchronous process is when communicating parties have to be present at the same time, a phone call, a meeting. Asynchronous, a text message or an email, is a form of communicating where you don't need to be present at the same time. So it seemed to me, in terms of convenience and a system that wasn't forbidding and that was accessible, an asynchronous process would be more attractive. I say it's about civil cases, but these technologies can equally be applied in family law, administrative law, criminal law too. I'm cautious about criminal law because it throws up its own unique properties, and there's currently a major debate on this. But overall, what I'm suggesting, as we move into the 20s, there'll be a shift from the presumption that we all have that all disputes before the courts are held in a physical space to the reverse. By default, and I don't know if it's 2025 or 2030, I think cases will be conducted in one way or another online unless there are compelling reasons to assemble in a physical courtroom. And it may well be this COVID crisis is actually flipping that presumption. What are the benefits? There has to be increased access if one has this kind of system in place. Fewer cases reach judges. Those that do will cost less. There'll be far less need for traditional physical buildings. But what's more important in terms of outcomes is what this means for litigants. Vitally, it provides a route to resolution where today many have none at all. It's more convenient, it's less costly, it's speedier, it's more understandable, certainly better for today's self-represented pro se litigants, and actually perhaps better for many representative litigants as well. Now, in the book, I point to a whole bundle of case studies. I think the best case study, we have the Civil Resolution Tribunal in British Columbia and Canada, but there was similar work that I draw attention to in China and Singapore, in England and Wales, Australia and the United States as well. Remember, this was all pre-COVID. Judges without courtrooms, justice without lawyers, quite heady and challenging ideas, and a whole bundle of objections are leveled against this, or have been in the years that I've been advocating this shift. Here's a couple. This is surely delivering an economy class of justice for people who can't afford proper courts. How can we have open justice in a system that's conducted online? How indeed can a trial be fair if you can't look all participants in the eye? Of course, there are many people who can't use the internet and they're excluded from this. Surely this also just encourages litigiousness because it'll be easier to raise actions. And then the legal philosophers, of which I used to be one, come out with a whole bundle of objections. This is contrary to the separation of powers in England and Wales. For example, this is actually impinging on our traditional adversarial system, becoming more inquisitorial. The notion of litigants without representation is deeply disturbing. And in fact, the whole common law system could be threatened by this because disputes will be resolved in an entirely different way and perhaps not giving rise to or addressing the difficult legal questions in the traditional way that gives rise to new decisions that allow us to replenish our legal thinking. And finally, people object by saying, look, this is a public sector technology project. Most public sector technology projects fail. Now, I think all of these arguments are important and they need addressing, and a quarter of my book actually does so. I would say this, but I don't think any of them in the end withstand analysis. There's two big points. I think critics, mainly lawyers, find it hard to look at the system through the eyes of users. They tend to criticize proposed reforms from the point of view of a lawyer who's practicing. And we see this again and again. And I don't think it's a helpful perspective when we're thinking fundamental reform. The second point is that in the name of justice, critics often miss the opportunity to reduce injustice. This fascinates me because both opponents and supporters of online courts invoke justice arguments to support the rejection or acceptance of this. But what I say of those who say that we should not progress with this technology and these developments. Often what they're aspiring to is some kind of, in the words of Amartya Sen, the Nobel Prize winner, in his book, The Idea of Justice, is a kind of transcendental conception of justice, the ideal form of justice against which they compare proposals for reform as against what Sen calls the comparativists, people who just say, well, what we've got today is actually not that great. So surely what we're trying to do in reforming is remove injustice rather than achieve some perfect form of justice. I couldn't resist it in my book. I mentioned my background is to teach jurisprudence in Oxford, but this really does require some, I think, analysis of what we mean by justice. And what I identify is 7 different conceptions of justice. And I think we have to measure all proposals for reform and our existing systems against these. I say that any court systems must deliver substantive justice, that's fair decisions, procedural justice, that's fair process, open justice, that's transparency, distributive justice, that means the court service is accessible to all, proportionate justice, that's to say that the service, the cost, the time, the degree of combativeness is somehow commensurate with the nature of the action. Enforceable justice, and here we can distinguish between private sector ODR, that the service has got the backing of the state, and sustainable justice, and this is a question with COVID, that we have to make sure these new systems are sufficiently and adequately resourced. So that's the first generation. The second generation, and I'm not going to dwell, and I even hesitate to talk about this because it then becomes the focal point of the discussion, but in the book, it's a couple of chapters out of 28 on artificial intelligence. I wrote my PhD in AI and law in the 80s in Oxford, so it's been my lifelong interest. And the question I've often asked and never really answered adequately is, can a computer replace a judge? And I address that again in this book. I think if the question is, are we saying can a computer work as a judge does, then neurophysiologically and neuropsychologically, we're a million miles from that. Are we saying, though, secondly, instead, that asking the question, can a computer system deliver decisions with reasons, because that's what judges do? I'm afraid, despite all the great work that's been done in the work of AI and law, we're still some years away from that as well. But the question I ask is, can online courts perhaps deliver the outcomes that court users want, but do so in entirely different ways? And in answering that challenge and looking at a different way, I look at prediction machines, systems that are being developed all over the world, many of which are said to be able to predict the outcomes of cases more accurately than human lawyers. So I just posit, I raise the possibility of predictions as determinations. Let's go back, say, to Brazil with its 80 million backlog. With all the will in the world, not all of these cases will ever be sorted out in the traditional way. But imagine if we said to parties this, that instead of being addressed by a traditional judge using traditional lawyers, we actually have a system that contains all past cases in your area of dispute, and on the basis of that can predict the likely outcome of the court. You say to these parties, would you be willing to accept that outcome as a binding decision of the state if, for example, the certainty with which that prediction is being made is 97% or higher? And I'm not advocating this, I'm simply putting it forward as a possibility. I know many people will say, well, hang on a second, current AI systems based on machine learning are opaque, and what about the bias in the data amongst the developers? Of course, they're key issues, and I address them there. But just to take a step back now, because the first generation online judging extended courts, the second generation AI, to take a helicopter view, in terms of transformation of our court systems, even the first generation leaking in a little into the second generation, largely for cultural reasons, in the book I said it probably takes about a decade to bring that kind of change. And nowadays, and it's an oversimplification, but I joke that it's taken a fortnight, because the reality is, with the tragedy of COVID-19, most physical courts have now shut. Remote courts have sprung up. Not all of them, or not many of them, in fact, are online courts precisely like the one I'm advocating. Many of them are audio hearings. Some of them are video hearings. I've been involved in setting up something called Remote Courts Worldwide. We have a website, www.remotecourts.org, where we've asked and are gathering together the feedback from around the world from all courts. We've now got about 33 different jurisdictions telling their stories, as it were, of what they've done in this very difficult period to use audio, video, and online techniques, given their physical courts have shut. And it's a transformation overnight. the early evidence, I think we have to say, is pretty positive. The feedback, I think most skeptics have been amazed by and large at how effective these systems can be, better than most accepted. But I want to stress, enthusiastic though I am, it's early days. What we're seeing is largely just now is automation rather than transformation. We're using technology essentially to audio or video, as it were, the hearings. We're not fundamentally changing the system, so it's less ambitious than I would want. Great for a start, clearly. None of this is artificial intelligence. We're simply allowing judges to conduct their work in a new and a different way. Another way of looking at what we're going through is that it's like a massive unscheduled pilot. It's like a huge experiment, a proof of concept. And some remarkable findings emerging. You look at Norway, for example, in their Supreme Court, very much in the spirit of my form of online court, on the papers alone deciding a difficult criminal case. Or in England and Wales, in the tribunal system, there's one very busy tribunal that's been using video hearings, and it's been so effective it's actually eating into the backlog from the old physical system. So lots of encouraging anecdotes and so forth, but to industrialize, because I don't believe we're going back, but if we want to industrialize and do this at scale, we do need systematically to assess what's gone well and what hasn't. We have to gather data from users, from court users, from judges, from parties about what's worked and what hasn't worked. We need to gather data on the technical issues, the business issues, the cultural issues, and we need to assess, and I would say by reference to my 7 categories of justice, the extent to which justice is being delivered. I used to say when people said to me, what's your arguments in favor of online courts? Where's your evidence? I used to say, there's no evidence from the future. But in fact, we now actually have evidence. And that evidence should in fact inform our policy making. Above all else, I think what this very difficult period has done is it's opened our minds to new ways of working. The final thing, just for a couple of minutes, I wanted to touch on was the global challenge of access to justice. 46% of people, as I mentioned at the beginning, only 46 live under the protection of the law. These huge backlogs. We hear that in the demand for legal aid in most civil cases, according to the UN, is largely unmet in most countries. About 1 billion people annually need basic justice care, but close to 30% don't even take action, according to Hague's research. So we're in a powerless state, and there's a justice gulf, this gulf between people being able to understand their rights and enforce their rights. And traditionally, for that gulf to be bridged, we need lawyers and courts. For the shadow of the coercive powers of the state to influence people who are otherwise not coming to reasonable solutions very often, if we didn't have the shadow of that coercive power of the state, we actually had people in a rather powerless state, knowing they were entitled but unable to enforce. And what I'm saying is the introduction of online courts will perhaps bridge that gap between being able to understand your rights and enforce your rights in an affordable way. And a project I was about to launch just before all of this happened was I wanted to look at the 4%. That's the 4% that would take us up to half of the people in this world being protected under the law and by the court system. That would be a few hundred million. It's a good start, it seemed to me. And within 5 years, I have this idea we can put in place a global platform, a standard technology, which will especially support emerging countries and developing economies to embrace a justice system, not in the traditional way, but using video, using perhaps audio, and certainly using online techniques. And so when the dust settles, as it will settle, I want to turn my attention back to this. So what does this mean in conclusion for everyone who's listening in, for the lawyers, the judges, the students, and others? What I call for is your support during the crisis in maintaining access to justice and therefore in maintaining the rule of law. This is not the time for lawyers endlessly to criticize reforms. This is a time to muck in together to make the most of whatever systems are available to ensure people have access to justice. Secondly, I would like lawyers and judges and students to be involved in what this means for the future of our courts, to be involved in rethinking the future of our courts. And finally, I hope at least some of you will join me in trying to solve the global access to justice problem. I think we can do this through technology. It'll take a lot of effort, it'll take a lot of will, but the tragedy of COVID-19 has actually given us essentially a platform upon which we can build. So while doctors carry out their vital functions of improving the health of nations, we as lawyers have got to help ensure that there is access to justice during the crisis, in coming years, and across the world. Thank you for listening.
Thank you, Richard. That was, as I knew it would be, an incredibly thoughtful and sweeping analysis of not just what's currently going on, but what could be going on. And I think at this very moment, it's critical for us not only to think about how to operate in our current situation, but also what this can teach us about how to make a better world going forward. There's no better person that I know to help us to think about bridging that gap between the past, the present, and the future than our commentator, Chief Justice Ralph Gants of the Supreme Judicial Court in Massachusetts. I've had the great privilege of knowing Ralph since, Justice Gants since law school, and he has always been a thoughtful person around these critical issues. He's now in the midst of trying to understand how to take a court system, which when he was running it just a few short months ago was totally a physical court system, or at least largely one in the way that we all think about, to one that now is almost completely virtual in various ways. And so Ralph, I call on you to give us some reflections about what Richard has said, and to begin a dialogue that, as I said, we will then expand to some of the terrific participants that we have here about these critical issues. So Justice Gants, thank you.
Thank you, David. First of all, I want to thank Professor Susskind for his fantastic discussion. I have little doubt that over the course of time, the issue will not be whether we will have online courts, but how they will work, how extensive they will be in terms of the scope of matters they will address, and when they will become part of the norm in many, if not most, of our justice systems. Let me, in terms of discussing what Professor Susskind had said, first of all, let's focus right now on the civil. I think he mentioned that the criminal raises separate issues. I certainly think it does. And when he speaks about civil, he is speaking really about smaller dollar or other types of disputes in which there rarely are attorneys, or at least not attorneys for both sides. So let's discuss those matters. I certainly agree with Professor Susskind that it would be a sad situation indeed if our court system became unable to address smaller dollar types of cases. I think right now it is fair to say that in most of the United States, perhaps most of the world, there really is no particular recourse for anybody who has a small dollar claim, except for maybe going to small claims court. And the fact of the matter is, we need for there to be an effective and efficient way to resolve those disputes at low cost and generally without the benefit of counsel. There are three types of those disputes which occur in our courts, and I think probably in most of the courts around the country and around the world. The first is what I'll call the small dollar disputes, which often are disputes which are resolved in either our small claims court or in district court. The second type of matters are family court matters involving issues of child custody and alimony, in which it is relatively rare for both parties to have counsel. And the third type of disputes are housing type cases, basically eviction type disputes. The dollar disputes arguably can be resolved by alternative dispute resolution outside the court system if the parties agree, because there is no necessary need, if the parties agree to resolve it that way, for a court to be involved. But courts need to be involved with regard to matters of family law, and courts need to be involved with regard to matters in terms of eviction of tenants from their homes or the foreclosure of individuals from homes that they previously owned. I am extremely interested in the formulation that he designed, and I think in terms of the how, I will mention that I've got various concerns, which is why, at least in Massachusetts, I have asked our Access to Justice Commission, which I co-chair, to take a look at the how before our court system does, because I am extremely concerned that if we do it in a way that is respectful of the needs of all litigants and does not place individuals in situations in which they're going to be taken advantage of. So let me speak of some of the concerns that I have, and I will invite Professor Susskind to respond to them. I have some concern with the asynchronous nature of judging. That is the idea that we're going to be essentially judging based on the papers. I have concerns, especially with regard to the smaller claims, because I'm not quite sure whether it may not be the case in the UK, but it certainly is the case in the US that most people can't write very effectively. They cannot articulate either the facts or their understanding of their argument very well in writing, and that it is only when they are allowed to present their arguments orally that they can become more articulate and better understood. So I do worry about a system which may rely entirely on written submissions, because I think a fair amount will be lost, especially for individuals who are not so well educated or perhaps not so well spoken in the language of their nation. In the U.S., of course, being English. And indeed, although he may praise those Supreme Courts which are deciding matters on the papers, at least my court really does not like to decide matters entirely on the papers, because there is enormous benefit from oral argument. Now, of course, on the Supreme Court, we deal with cases which by their very nature are matters which involve complex matters, often changing and evolving issues of law, sometimes issues where there are conflicts among our courts. But the fact of the matter is oral argument helps us to decide the case more wisely. And even though we have excellent briefing by quite able attorneys, I will say that in roughly 20 to 25% of the cases, the oral argument changes something about where I am in terms of the decision. It may not change that it may not change it from thinking that the defendant will win versus the plaintiff, but it may arguably change part of how I believe the case should be decided. And that's in cases where we already have well-presented written arguments and still are able to flesh out ideas or facts or concerns that may not have been articulated that well in writing. So I have some concerns about the reliance entirely on the written submission as the basis for deciding. I also have concerns, as he does, as to what I'll call the asymmetry of knowledge and skills. About 40 to 50% of the small dollar disputes in Massachusetts courts involve debt collection. And very often those debts are debts which have been purchased at 2 or 3 cents on the dollar by debt collection agency, taking debts which have not been collectible, and they then go to court and they seek to collect them. And even if they collect only a small share of them, since they paid only 2 or 3 or 4 cents on the dollar with regard to those claims, it is still economic for them to present those claims in court. When individuals have lawyers, it turns out that those debt collectors very often cannot prove that they actually own the debts because they purchased them in a securitized debt package, and Appendix A may identify all of the debts they purchased, and more often than not, no one can actually find Appendix A and be able to prove that the debt which they're seeking to collect is indeed the debt that is owed. And very often the debtor may not even know who the debt collection agency is. They may have gone to Best Buy and purchased a TV system, but it may not be Best Buy who is actually presenting that particular claim. The claim may have been sold to a debt collection agency, and it may be somebody who they have no clue who it is. So I do worry to some extent about the ability of those individuals to understand their rights well enough to be able to defend them in a court of law. And again, Professor Susskind has recognized this particular concern in terms of making sure that there is adequate understanding of the law. But again, there is concern about people's ability to read and understand the written word in terms of understanding their rights. There also are issues, certainly in Massachusetts, and I think in many countries throughout the world, with regard to language access. The ability to, we have probably about 100 languages spoken even in our Massachusetts courts, and the capacity for individuals to be able to have the translation of the written word and the interpretation of the spoken word is an important part of all that we do. Finally, when we do it, and as I say, I do think the question is not going to be whether, but when, it will have to be accessible essentially through a smartphone. Virtually everybody, at least in this country, has access to a smartphone, but not nearly as many have access to computers. So a system which is going to be relying upon computers is not going to be nearly as accessible as those which rely upon a smartphone or the means which individuals can do to text or what they're familiar with in terms of the presenting of arguments. So again, I think it will happen. I am concerned that it happen in a manner that's going to be respectful of the interest of all litigants and not put any at an advantage or disadvantage because of issues of education, language access, or other concerns. Let me speak for a moment about where we are, because this goes to the question of when. I think it is fair to say that the resistance to online dispute or virtual resolution of disputes has changed dramatically over the course of the last month and a half. My courts are essentially physically closed. Virtually all that is being done virtually. We're proceeding virtually with an IT system which is less than we otherwise would have hoped for. We are improvising in all sorts of imaginative ways. Many of our courts are becoming Zoom courts. We are hearing emergency hearings with regard to individuals who are in custody, who are seeking release because of the dangers of being in a jail or prison during this period of time. And we're holding literally hundreds of those hearings, and they're being handled either by telephone or by Zoom or through some other virtual way. We are doing things that we have never done before because we have no other choice. But I think the fact of the matter is that we are discovering that a fair amount of this stuff works pretty well under the circumstances. And I think it is also fair to say that when this ends, and I don't know when it will end, but the one thing that I am certain of is that we will not be going back to where we were on March 1st when the pandemic ends. I think you're going to see courts having more and more matters handled remotely. And I think that, although Richard focuses on the fact that that is still essentially the old way of doing things in a somewhat different format, the capacity to be able to require individuals to come to court less often will make an enormous difference in terms of reducing the cost of litigation so that more people can afford to have lawyers involved in the matter, because the matters can be handled more efficiently if they don't need to come to a physical courthouse. And for individuals who are representing themselves to be able to reduce the number of times they need to come to court can make an enormous difference for those individuals who are struggling to come to court because of problems in terms of their job, their responsibilities at home, either with regard to elderly parents or with regard to children. So to the extent that we're able to handle many more matters remotely than we are now, which I think will be one of the consequences of this pandemic, I think it will substantially change our ability to handle various matters more efficiently than we do today. And with that, I will invite Professor Susskind to respond and then invite questions.
So, Justice Gants, first of all, thank you so much for that very thoughtful and again comprehensive look, both of the possibilities and also the challenges and what's happening today. I think I'm mindful of the time, and particularly because some of our initial questioners actually have to leave right at 1 o'clock. So I think, Richard, rather than asking you to respond right away, what I'd like to do is to invite our three distinguished guests who have agreed to ask preliminary questions to each ask their question. And then both you and Justice Gants, both of our panelists can respond, and then we will, again, for those of you who are able to stay perhaps until 1:30 or so, we'll have more time for more discussion. And we've gotten some fantastic feedback and questions coming in on our Q&A function. So why don't I first turn to the current ABA president, Judy Perry Martinez, who is, again, I've been blessed to know for many years, and who has already been doing fantastic work at trying to make sure that legal services are not forgotten in this time of crisis. And I know has thought a lot about these issues. So Judy, do you mind if you could ask the first question? That would be fantastic.
David, thank you. And thanks to the Center on the Legal Profession for all it's doing to assemble this crowd, which really shows how much lawyers and so many others care about these issues. To Chief Justice Gants and Richard, Richard's Remote Courts Worldwide website provides a hilltop view of innovative measures being undertaken by courts around the globe. And in each instance, I think all of us would agree that sustained and optimal service by courts in civil cases, and thus justice itself, is dependent upon early and continuing input by consumers of justice. Are you each seeing evidence? We heard some of this from Chief Justice Gants, but are you seeing evidence, and if so, what, that courts around the globe are taking steps to assure that the voices of consumers of justice, the self-represented, those without access to technology, the disabled, and importantly, counsel, the greatest users of the court systems, are a part of the new equations for serving the public at our best and instilling justice, in justice, the confidence and trust of the public?
Thank you so much, Judy. And again, thank you for everything that you're doing on behalf of the profession and access to justice more generally. Again, let me just get each of the questions there, and then we'll have a chance to respond to everything that's on the table. Justice Chandrachud, may I ask you to go next? As one of the commentators, the people in the chat pointed out that you've recently stepped down from being the Chief Justice, but your voice is still incredibly important worldwide, and you have been thinking a lot and talking a lot about the fact that in India, you're not going back, and that online courts are here to stay. And so I wonder if you could share a question or thoughts with the panelists.
Professor Wilkins, and that's an amazing presentation, Professor Susskind, and my thanks to Chief Justice Gants as well. My question is this. There is a technological divide in many countries across the world between those who have and those who don't have access to technology. Now, we are in a complete lockdown in India since the 23rd of March, and we have 17,000 courts across the country. Though there is a lockdown, justice cannot be stopped. So we have launched onto the virtual platform. We have video conferencing in all courts. But my question is this. As we enter the era of virtual courts and online courts, how do we ensure that the technological divide does not result in a dilution of access to justice, particularly to those who are on the wrong side of the technological divide? Would this necessarily therefore mean that there has to be a shift in our model of justice, a shift from the users of justice seeking out justice to justice seeking out the users of justice? How do we then really confront this technological divide?
Justice Chandrachud, again, I've been fortunate to have a chance to interact with Justice Chandrachud many times in my work in India, and that's a very, as always, thoughtful and perceptive question. Our last commentator is Rochael Soper Adranly, who I've said is a partner and the chief legal officer at IDEO. And again, we've at the center been very fortunate to be working with her on a range of projects, and she has been involved very much in helping to think about redesigning the justice system in general, particularly with respect to access to justice. And Rochael, please share some thoughts or questions with the panelists, and then we'll open it up to the panelists to respond.
Absolutely. Thank you, David. And thank you so much, Professor Susskind. I had the pleasure of sitting on a panel with Daniel at a Hogan Lovells partner retreat a couple of years ago, and he argued magnificently on behalf of many of the points you made today. And Chief Justice Gants, thank you so much for your comments and highlighting the particular areas we have to be super sensitive to when making these changes. I'm just today completing a class called Law, Justice, and Design that I'm teaching with Martha Minow. And in that class, our students have tackled different access to justice problems. One of the teams went to housing court one day and sat, this is before the pandemic, and watched that default judgment after default judgment after default judgment was entered because the tenants were not at court. And they were so troubled by this because they're imagining this case where law and justice work perfectly. And because someone is not physically there for any reason, because childcare, transportation issues, they can't leave work, they didn't know they were supposed to appear, and there being a default judgments entered against them. So I love the idea of thinking of court as a service rather than a place, and the shifts that are happening here. My specific question is, where there is likely to be resistance, and there is likely to be resistance from lawyers or people for whom the system has worked well for, what is the incentive for them to begin to embrace the change? I think there are things that are forcing change, but there needs to be incentives for people who are sort of steeped in the current process to change. And I'm curious how you've thought about those incentives.
Thank you so much, Rochelle, and thank you for sharing your time and your wisdom with our students. It's really meant the world. What I'm going to do now is perhaps ask Professor Susskind to begin. There's a lot on the table, Richard. You can't possibly respond to it all, but I think there are some common themes, I think, that came through with Justice Gants' brilliant remarks, and then our three questioners. And if you could start, and then we'll ask Justice Gants to chime in. And while this is going on, we at the center are going to be trying to synthesize some of the themes and questions that have come through in the question and answer function and the chat function. And I'll be sort of posing those themes to our panelists as we continue the discussion. Let me just say very quickly, since we're close to the 1 o'clock hour Eastern Standard Time, that for those of you who have to leave, and I have to say there were over 1,300 people who were on this webinar at one time, which is quite remarkable, and way more than 60 or 70% of the people who signed up. It's just a focus of how important these issues are. I just want to thank all of you who were in attendance, promise you that we will send you information. Some of you have asked for links to Professor Susskind's book and to his website and information about the center. We will send that. Finally, I'm just going to thank right now my tremendous team at the Center on the Legal Profession, Brian Fong and Tim Shea and Sonali Howe and Ralph Badalate and Sarah Freeman Aliman, who were responsible for helping to put this together. Never would have happened without their terrific work. So with that, let me turn it over to Richard. And as I said, we'll go at least till 1:30, and our participants have been so generous to agree to stay. So Richard.
Let me just echo my thanks to Brian in particular, who's helped set up this webinar, and David, of course, to you for your support today and your support generally. I think particularly vital is that you do send people details of the book, if I may say so.
Yes, I promise.
It's always hard to know how humor works across the internet, but there you go. I thought what might be best in the first instance was just to skip across the surface of, if I may, of each of the observations that were made and offer a preliminary set of thoughts. Chief Justice, in response to yours, I just want to stress that, and it perhaps doesn't come across in all of the book, that what I'm not suggesting these techniques should displace all conventional hearings. What I anticipate is we'll see in the future a blend of physical hearing, of audio hearing, of video hearing, and of paper hearing. And what I urge us to think about is which parts of the process are best suited to each of these different techniques. And I'm pretty sure that when we do the analysis, and a lot of this analysis will come through from our investigation of the COVID courts, when we do this analysis, we'll find which techniques are best suited. And I think that'll both increase access and increase efficiency. And so I share many of your apprehensions if the idea was that an asynchronous online court would be used on all civil cases. But I think there are many components and particular types of cases for which this is very well suited. There's one thing I draw attention to in the book, that is one of the great unanswered questions, is what cases are suitable and what cases aren't suitable for this kind of technique. We need to do more work in this. But I also wanted to take issue with me and you, as it were, because although I do focus on low value civil disputes, one of the common reactions of arbitrators who read the book was saying that actually in very high value disputes, we're already using these techniques. Many interim decisions are made on the basis of papers alone. And indeed, we think for many final decisions might be delivered in that way too. And so while I focus on low-value civil disputes, I think I'm certainly nudged by ambitious commercial judges and by vigorous arbitrators to extend the thinking beyond the low-value civil dispute. As for Judy's observation, I think she's really putting her finger on something terribly important here, that part of the study of the impact of the remote courts we're using just now has to take account not just of how judges and lawyers feel about it, but how users, and particularly self-represented users, have found the process. And this is what I say, it's like a massive experiment, and we have to make sure that we're capturing as much data as we can, or at least leaving ourselves the opportunity to capture that data, so that, and I'm sure Rochael would approve of this, that we can, in a sense, design thinking can inform our reformulation of how our courts work. In a way, the courts are too important to be left to judges and lawyers to redesign. I think we need to be thinking about how it is that court users find it most comfortable to interact with the justice system. And for the former Chief Justice of India, who talked about the technological divide, which is something I address, and of course I can't speak for all jurisdictions, I do tend to say in England and Wales, I think it's an exaggerated concern to the extent that effectively only 5% of people are excluded in our country from access to the internet. Some of them are proxy users, might not be direct users. It's not to say for a second the 5%, the hard to reach, aren't terribly important. But what I hope is if we can make it easier for the 95%, we can direct more resource to those who genuinely need help. I don't think the fact that, say, 5% are excluded is a justification for saying we shouldn't change. And a lot of this goes back to my old argument in the book about the Voltaire point that the best is the enemy of the good. Very often people say, well, we shouldn't bring about this change because X, Y, and Z would not have access. And I'll say, well, actually, they don't have access today, but this will give access to A, B, and C. So the test is improvement, not perfection. This is the transcendental versus comparative point. Again, what I can't speak for, although I know in some countries, is the level of internet usage and internet access in many other countries. But if you look at something like the work that's being done in Uganda by the Barefoot Lawyer team, you'll see in countries, even with relatively modest technological capability, the mobile phone, as Chief Justice mentions, is a standard platform. Electricity may be a difficulty, but we are seeing the rapid, some would say exponential, increase of technology, even in developing countries. And remember also that when we're designing and thinking about systems for the future, we're not thinking about systems for the users of today. We have to anticipate what will be the level of usage of these technologies in, say, 5 years' time, and meet the needs of that market, not the needs of the market, what will then be 5 years ago, as it were. As for the incentive to change, most people would say that the change in conservative professions or institutions is unlikely unless there's a burning platform. And it's a fairly standard mantra within the legal profession that the platform is not burning. I often say, unhelpfully, some would argue when I'm speaking to firms of successful law partners, that it's hard to convince a room full of millionaires that they've got their business model wrong. But the reality is, if you're a litigator earning handsomely from the old system, you won't necessarily be rushing to online courts or rushing in support of online courts or remote courts. What, of course, is both tragic and fascinating about the COVID tragedy is that the platform is burning. The iceberg is melting. There has been no choice. The question is, and it's one I think that Chief Justice answered for us, will we, when the platform cools down, if I can push the metaphor a little further, will we step back on, or will we be too far adrift? And my hope is what the incentive should be is lawyers remembering again that what they thought about perhaps more in law school, that it's great, of course, to earn a good living from the law, but we should also be concerned about access to justice. We should also be concerned about ensuring the rule of law is maintained. And we should be, frankly, collectively ashamed of a profession and of an institution that excludes almost everyone. If our current methods of resolving disputes are unaffordable, far too time-consuming, unintelligible, the motivation to change should be that we care. We care that people in our world have access to justice.
Thank you, Richard. Justice Gants, would you mind responding a little bit or giving reflections on what you've heard?
No, I mean, I'll make 4 points. One is, I think one of the most valuable and the easiest uses of what Professor Susskind has described is what I'll refer to as the triaging of cases, the ability of using online disputes to mediate matters so that only those matters which cannot be resolved by the parties reach a court, whether it be a physical court or whether it be a judge acting virtually. In housing court cases, landlords don't generally want to evict individuals. And if they can resolve the matter outside of a court, that often is best for both the landlord and the tenant. Similarly, with regard to marital disputes, to the extent that those can be resolved simply without having to go back and forth to court, raising individuals upset about the entire experience, we're all better off. So at the very least, the online dispute resolution means can minimize the number of times that people actually need to come to court and actually have the matter decided by a judge. And that's an enormous advantage in so many cases. With regard to the question with regard to the user experience, it is absolutely essential that courts be in touch with the users who she was making reference to. In Massachusetts, the Access to Justice Commission has established actually a COVID pandemic group, which is presenting the user experience to each of our trial courts, and the trial courts are taking what they've learned and adapted what they have heard to the needs of the individuals. I'll use the example of domestic violence victims. It's hard enough for domestic violence victims in a normal world, but in a world in which they're basically housebound, and have to explain why they are leaving the house when they're supposed to be sheltering in place. The challenges to allow them to be able to be heard are tremendous. And we have been adjusting the process to allow telephonic hearings for those individuals to be able to reach court by telephone, as opposed to physically having to leave their homes. So listening to these individuals and adapting to their needs is absolutely essential. With regard to the users in terms of areas in which individuals have limited technological capacity, I think you take the user as you find it. In many ways, simple is better. A telephone call may not be as impressive as a Zoom hearing, but in the vast majority of cases, you can resolve disputes almost as effectively through a relatively primitive form of technology that is a mobile phone. And as to the issue of the resistance from attorneys, I know that Professor Susskind has been focusing on this being not limited to smaller dollar claims or smaller pound claims in the UK. But the fact of the matter is, in those cases, there aren't lawyers anyway. As he points out, in the vast majority of those cases, there are very, very few lawyers involved, and there's very little money to be made from those cases. So we've heard this idea of lawyers being resistant to access to justice initiatives. But the fact of the matter is, there are very, very few lawyers already involved. It's important that the individuals who are representing themselves have the ability to effectively do so. And also, to the extent that we accomplish much of what Richard has to say, we'd be reducing the overall cost of litigating cases and improving the capacity of individuals to afford lawyers, because lawyers will be able to perform their role more effectively. So I think all in all, it is something which can be sold to lawyers as making their process more effective, especially as clients become more concerned about the cost of retaining lawyers. It arguably expands the number of cases which lawyers can take in a cost-effective manner.
Thank you very much. We've had some actually terrific comments that have come through in the Q&A, and we've tried to synthesize them into a few big themes. Let me start with this one, which has come up a lot and is something that's actually being actively discussed in many systems, which is the idea of online juries. Now, many of the countries around the world may not use jury trials in civil cases, but our system does here in the United States, and it does so in some circumstances in the UK and England and Wales and Scotland as well, and in other jurisdictions. And I wonder what each of you think about this proposal, which is now being actively discussed.
There's a lot of controversy about this just now, and I've been giving it thought and been in discussion. My initial reaction when I was asked to advise on this a couple of weeks ago, and I continue to think this, is that I would dearly prefer, obviously I prefer that the crisis came to an end, but if we were talking about not being able to hold jury trials for months rather than years, my inclination would be to hold on until we can hold physical trials again. I say this for a number of reasons. It worries me that we have no evidence at all about the use of online techniques in jury trials in action. There's a very interesting pilot being run by Justice in England, which is looking at the possibility. But if you look at remotecourts.org, and we've been in touch with contributors to this, that we don't have an evidence base upon which we can draw. Quite different actually in video conferencing and audio telephone conferencing and indeed in paper hearings. These weren't common or popular in the past, but they've been used sufficiently. We'd be able to study them and understand their basic operation and predict that they could be robust enough. So I worry there's a lack of evidence. I also worry I'm half a lawyer and half a technologist. The technologist worries that it's never advisable to start with very complex systems. Most system development projects that succeed start with fairly simple routine work. We learn, we refine, we iterate, and we get steadily more complicated. Those that are very ambitious and that jump in and try to address the most challenging tasks by the use of technology actually have a far higher failure rate. And so the theory of disruption in technology is you should start with simple issues. Worries me a little also that the jury trial is symbolic in many ways of the justice system, and in a time of great uncertainty, it does seem to me that some of our institutions and our practices are fairly foundational, and we might not want to change them overnight without due consideration. So the concern is we're going to rush in. However, if the proposition is that physical courts can't open until, say, early 2022, then we're going to have to put all the options on the table. Will that be an option, for example, to run some cases without juries at all, judge only? Will that be an option to have some kind of social distancing set up across a range of rooms in a physical courtroom? Or will this require us indeed to follow the model that Justice is pursuing, which is essentially to take the traditional jury trial and drop it into the equivalent of Zoom? So say, I think we need to do quite a lot more research and experimentation. Isn't it interesting, the process in medicine of the clinical trial, how rigorous and systematic and how long that takes, frankly? It does seem to me with the jury trial, we should be bringing the same kind of rigor and analysis. But I do accept that if we have no choice, it may emerge that the online jury trial, the remote jury trial, may be the most preferable of a range of worrying options.
Justice Gants, any thoughts on that?
Yeah, I mean, I was a trial court judge for 12 years and have enormous confidence and faith in juries. There is something remarkable that happens when you take 12 individuals from the street and select them as jurors, and then they become judges of the fact. And the fact of the matter is, something remarkable does happen when individuals sit as juries. And I do worry that that may not happen in the same way if they are sitting at a computer attempting to examine a case. I also worry, especially in criminal cases, at the extent to which when you're in a courtroom, that individual is very much a human being, as are the witnesses, as are the victims. And I do worry that seeing individuals on a screen may diminish the humanity of what goes on in the course of a court of law. At the same time, as Professor Susskind mentioned, we're trying to figure out how we can do jury trials again. I actually asked my jury commissioner to put together a plan. How are we going to impanel juries? Generally, right now, we bring about 60 or 80 jurors into a courtroom, and we often have individual voir dire, and we select individuals on the basis of considerable questioning done at very close quarters. trying to figure out how we're going to get back to jury trials for individuals, especially who are in custody awaiting trial, is an enormous challenge. I think we will find a way. It will take some improvisation. It may mean encouraging defendants to accept a 6-person jury as opposed to a 12-person jury. It may mean we have only 3 jurors in the jury box and the other 3 across the courtroom in an improvised jury box. But I think I'd like to find a way to maintain the physical jury trial even during the course of this crisis.
David, can I come back on one point?
Sure.
The Chief Justice said, and he has to be right, that something remarkable happens when you assemble these 12 individuals. We also have to be open to the idea, I think, that something remarkable might also happen if we innovate and try to run jury trials in quite different ways. I'm conscious, for example, of this meeting. We've had 1,300 people together, where if David, with all the will in the world, had been wonderful to have been there and would have had a meal and a chat and would have caught up, would have been lucky to have 60 or 70 people in the room. And so this was really my transformation rather than automation point, that it's sometimes the case when you use technology that allows us to do things in ways that weren't possible and delivers benefits that we couldn't have anticipated. And so I want us to be open to the possibility right across the use of technology in the courts that remarkable new benefits could arise that are beyond our current contemplation.
Well, on that note, we've had several questions that are around a theme around, let's say, what is this likely to do with respect to issues like judicial independence or corruption in the courts? For many of our listeners who are listening from around the world, these are major everyday issues that lawyers and judges and litigants face. And is there any thought about how the move online or from synchronous to asynchronous? Richard, you spoke a little bit about this with transparency being one of your principles of justice. How do we think about that in a world, particularly if we overlay the issue that we've already talked a little bit about, people's understanding of technology, not just in its use, but actually what it's doing or not doing is actually, there's a huge range. So speak a little bit about that feature of the court system or of our justice system around independence, fairness, transparency, accountability, lack of corruption.
Yes, I talk about this a bit in my book, and again, I'm maybe a little bit focused on the English system where our judges are appointed or not elected. And people ask me questions like, how do you know if a judge is paying as much attention in an online court or a video hearing context? And how do you know if it's an asynchronous process that they'll read the papers as thoroughly? How do you know if they're not in the confines of a traditional building, they'll take their position as seriously? I take all these criticisms and challenges a little bit of indictment of our judiciary. I like to think that the online courts I'm envisaging are still populated by appointed, selected individuals of considerable integrity. And it seems to me that these are people I would trust to settle disputes, whether they're doing that from the kitchen table or their chambers or a physical courtroom. And so, but there may be in different legal systems, different sorts of individuals in judicial roles, and maybe my confidence is ill-founded in respect of other jurisdictions. The transparency point is very interesting. There's so many, I've got a whole chapter on open justice and transparency, and the instinct of many people, particularly for the asynchronous process, is to think, well, hang on, this is a closed process. How on earth can we witness the law in action? How can we essentially walk off the pavement into the courtroom, and so forth? And I draw some distinctions between, say, real-time transparency and information transparency. Real-time transparency is the ability to observe a court hearing live. And actually, we're seeing that very much in practice in many of the video hearings today. Information transparency, in some ways, for me, is more important. That we have detailed, analyzable information about our courts, about the cases that go through the courts, about the outcomes, who's heard the cases, the parties involved, how long the hearings take, how long the decisions took to deliver, how these compare to other cases, and so forth. And my overall conclusion, again, this won't be surprising for someone who's writing a case, really the case for online courts, but I believe that these techniques will give rise to a more rather than a less transparent court system. I think they will increase rather than decrease open justice. But they do require, for many of us, and it's the same in all other professions, they require a little bit of a psychological shift. We may be delivering the outcomes we require in terms of openness, but in different ways. If the question is, can, through technology, we exactly replicate what goes on in a courtroom, the answer to that is always going to be no. If the question is, can we deliver the outcomes that court users want and that our society and economy requires of an independent public judicial system, I think the answer is yes. And so it goes right back to my power drill and my hole in the wall. We shouldn't fixate on the power drill and preserving the power drill with no alteration. What we should be thinking about is that hole in the wall and understanding how we can serve court users better and uphold the rule of law to a greater extent, increase access to justice. And so when we're talking about fundamental values of independence and transparency, I argue quite strongly in the book that the online environment will increase rather than decrease. That's not to say there aren't problems and issues, and I'm sure Chief Justice Gants will draw our attention to these. It's to say that these issues have been thought through. You may not agree with my arguments, but at least I've given them some thought.
Justice Gants?
I do agree with his argument. I do think the key is transparency, and I do think he is correct that the capacity to be able to take a volume of a judge's decisions and be able to analyze them and see who wins and who loses over the course of time would arguably provide more transparency than we presently have. I add only one thought, which is one of the things which all of us learn and have learned, I think, from studies as well as from own experience, is that justice is not only the result that emerges, justice is the feeling that somebody has been heard. And I do think it is conceivable in a virtual setting to be able to accomplish something akin to persuading somebody that indeed their argument has been heard. And that is one of the dangers of purely written responses, is because you don't know whether or not the argument has been heard. I think there are ways around it. I don't think that's an argument necessarily against virtual resolution of disputes, but I think it is one of the things which judges who are resolving matters virtually need to be respectful of, to make sure that the litigants understand that they have been heard or read, or that there is some appreciation of the arguments that they have been given.
And here's where it becomes really interesting for policymakers, because they have to make some fascinating calls here, because you might have to balance on the one hand a system where, with all the will in the world, we can't be sure that parties are heard as effectively as the traditional way, but a system that's made available to a far wider range of people. This is where you've got different forms of justice pooling in different directions. And I say quite often in the book that I'm more of the lawyer philosopher school, where we can raise objections again and again to the defects of the proposals. But if you're a policymaker, if you're, as it were, and a politician, if you're in the arena, our politicians have got to make, and our policymakers have got to make practical choices about the future of the justice system in light of the experience we've just gone through. And it'll be precisely this kind of tension they're going to have to resolve.
Well, that's a way of actually entering into a related topic that came through in many of the questions, which is, in some ways, you've talked about this, Richard, in your book, and Justice Gants in your remarks, as something that we can think about primarily in the routine, the easy or the lower tier cases, and that things get much more difficult as we think about this in more complex issues and issues that raise more fundamental issues around the public purposes of our justice system. Let's call it, big issues around freedom or democracy or principle. But I wonder how easy it is to make that separation. In other words, take a case from our US constitutional vantage point, Goldberg versus Kelly, which is one of the more fundamental pillars of our constitutional law about the right of a hearing. It grew out of a very simple, small welfare dispute. And we see that in many ways, at least in the common law world. And so the question is kind of how easy it is to segment the simple and the routine from things that could have wider application. And that might also go to another part of the question people asked, which is this only for trial proceedings? Does it apply to appellate proceedings? How do we separate the two, and what's the record look like in the appellate court if the trial court has been done in this way? So think a little bit about that segmentation question.
I'm looking uncomfortable, probably wriggling a little bit, because this takes me back to the 80s, because it was a fundamental issue in my doctorate that was really a weakness in the doctorate, which I was praying my examiners never ask about, and in fact they didn't ask about it. But the late great Ronald Dworkin, when he read some of our work, brought it to my attention immediately. And the point was this, that I was talking about AI systems, and I was saying they'd be very useful for sorting out what I called, rather pretentiously, clear cases of the expert domain. And by what I meant was the kind of legal problems that for an expert are really straightforward, but for a layperson, it would be hopelessly difficult. And there's enough of these problems, these everyday legal problems, that I thought our computer systems could help with these. I wanted to distinguish between these easy, clear cases, as the jurisprudential literature refers them to, and the hard cases, the cases that raise really difficult questions of principle or policy, or of the underlying purpose of legislation and so forth. And it seemed to me that certainly with the technology available in the 80s, these harder cases were well beyond the capabilities of these systems. So I introduced this I simply replayed the common distinction between cases that were easy, systems could solve them, cases that were hard, you need the traditional judges. And so the Ronald Dworkin point to me was that actually whether or not a case is easy or hard is often, in fact, may invariably be a hard question. And it's not just a nice philosophical point, it's an absolutely vital point. And it plays right through to these simple systems that people are maybe suggesting for the use of AI to resolve disputes. And these systems may make an assumption that cases are easy rather than hard. And I think there's some great research that we've done there. That I'm hoping there's some academics and students listening in, because I find this intractable. What is it that makes a case easy, and what is it that makes it hard? And if we don't know this, how do we know how to allocate cases across our system to human judges or to computer systems and so forth? And it occurred to me that we could do some great research in this, that we could actually, on the basis of machine learning, do some analysis of the data associated with cases that are easy and the data that's associated with cases that are hard, and see, and this won't be a causal connection, but see if there's any interesting correlations. And it may well be we could develop a system that could identify more accurately than expert lawyers whether or not a case raises difficult legal questions or not, and that system would know nothing about the law at all. And that's the same as these systems that predict the outcome of disputes. They know nothing about the law at all. They're just based on computational statistics. So I've taken a little tangent there for you, David. It is we'd have done that if we'd been there physically in person. But I think it's important to see that there's some quite interesting theoretical issues actually will have to be sorted out before we get the architecture of these systems correct, and before we can be confident that we're allocating cases to the right part of the system: physical courtroom, online hearing, video hearing, audio hearing.
Justice Gants, any thoughts on that?
I'm going to push back a little bit, as much from what you said as from what Professor Susskind said, which is this idea that there are so-called easy or lower tier cases as opposed to more complex, higher tier cases. Certainly in terms of the dollars involved, yes. Arguably in terms of some of the legal issues involved, perhaps. But the fact of the matter is probably 70 to 80% of the cases that are in our state court system are what I call the cases involving everyday legal issues, cases involving family disputes, housing disputes, and let's also include administrative law matters which don't come to court, such as the welfare dispute that you just described. They may not involve a lot of dollars, but they may be quite complicated. The issue of who's going to get custody of a child is not so easy. And you can understand the challenges involving that. The issues of whether or not you're going to evict an individual from a home where the landlord may itself have failed to maintain the home in a manner that's habitable, and what circumstances may occur that may justify the individual's remaining. Those issues are often very, very complicated, which is not to say, by the way, that they can't arguably be assisted through AI. But it's not going to be a simple boilerplate formula, that the calculation of who should prevail in these cases and the challenges of judges in deciding these cases is often very, very difficult. So it is, I think, much easier to decide a very complicated corporate dispute where only money is involved than it is to decide who's going to gain custody of a child when one parent may be living actually in one country and the other parent is in a different country, and both of them have been good parents. So I don't want to underestimate the challenges involved on the so-called lower tier cases. They have their own complexity and certainly their own importance to the parties who are involved.
I think that is just a critical point, and it's one that really leads me to ask you to perhaps give your last reflections. And I'll just say, to show both the importance of this issue and the incredible high caliber of our participants, about 75% of the people who joined this webinar at the beginning are still here. It's over 800 people. I mean, that's really quite remarkable, and it shows how important this is. And that's why I want, as the kind of last question, to have you reflect on something that came up a lot in the Q&A, which is, even if I'm convinced by what you're saying, how do we convince others? That is, what are the arguments that we can make to policymakers, who Richard is, after all, correct. It's policymakers, it's other chief justices like you, Ralph, or others who are in charge of court proceedings. What are the arguments that we can make to at least move us along this path, or entertain a question of serious inquiry about how to move, which I think, Justice Gants, in your last comments, you absolutely suggested is a complicated question at all levels. And Richard, in your book, you point that out as well. And I know you devote a little time to this in the book, but I think to leave our participants, at least for this stage of our discussion, if each of you could say a few words about the way in which perhaps we move this argument forward in our current reality, but moving on from that current reality into what we see as the foreseeable future. Richard, do you want to begin?
More than happy. I often say that lawyers and judges are more convinced by evidence than argument. And that's been one of the difficulties in my own books. I often joke I write the same book every 4 years, but I've written quite a few books on this. And you have, of course, people who approve and others, and this is the natural tendency, I think it's the training of the lawyer, to say, well, here are the 4 things that are wrong with that. And you descend into argument and counter-argument. What is hard to argue with is evidence. And this is why I stress again that this period is so important for us, that we have this live, real-time experiment in the use of some of these techniques. We should be capturing the data, marshalling the evidence, not just arguing slightly idealistically, as I tend to do, for these changes, but showing in practical terms how it is these systems increase access on the one hand, and frankly, will save costs on the other. So we're going to have a different kind of discourse now, it seems to me. We don't want, I think, to spend several years being dominated by social science. On the other hand, we also don't want new converts simply leaping to say, this is the way ahead. The case for online and video hearings has been made beyond any reasonable doubt. But what we have to do, I think, in a measured and systematic way, is assemble the evidence that we're gathering around the world in favor of a major change. So the shift is from argument to evidence.
Justice Gants?
I would say the single best argument in favor of what Richard has been presenting is to listen to the users. He has pointed out that if you see the world through their eyes, and I would quote Roby Burns, but I'll let Richard, who's a University of Glasgow graduate, do that instead, to be able to see the world through their eyes, to be able to understand how they understand the experience, to recognize that they, in most situations, rather be at home or rather be at work than be in a courthouse, and be able to resolve those cases with the least amount of time and effort and burden and hassle, to be able to understand how they see the world and to be able to adapt to them, and also recognize that the vast majority of those individuals, as he has described, are doing or trying to represent themselves without the benefit of counsel. And if we truly listen to their experience and understand what they're going through and recognize that what is happening now is simply not good enough, that I think is the strongest argument for the type of change which Richard has been proposing.
I don't have my copy of Robert Burns to hand, it's somewhere behind me, but it ran something like this, with the Lord, the gift of us to see ourselves as others see us. I think it's a great way to end the event with Robert Burns. Back to you, David.
I think it is a fantastic way, because we have actually modeled that by showing the perspective through the eyes of an incredible group of participants. And I just want to thank again Judy Perry Martinez, the president of the ABA, who took time out of her incredibly busy schedule to offer her eyes and ears and voice about this, what she's hearing and seeing and thinking. Justice Chandrachud, who I both first promoted before his time to Chief Justice, but then demoted, saying that he was off the Supreme Court. He's actually a current Supreme Court Justice of India who will be the Chief Justice quite soon. And I think after hearing from him, we are all will be the better for it. And certainly the Indian justice system will be. And my dear friend, Rochael Soper Adranly from IDEO, we need her kind of creative thinking, both inside the law as a practicing general counsel, but also outside, bringing the best of the thinking of design. How do we think about this? Of course, our incredible participants, Richard Susskind and Chief Justice Gants, who've offered amazing insights. And I'll just say on behalf of the Center on the Legal Profession, this is what we're dedicated to doing, which is to try to assemble the kind of research about our current moment, about how to think about it, not just here in the United States, but globally. And we will be letting all of you know how, if you're interested, to stay engaged in what we're doing and these issues, and to try, most importantly, to convene conversations like this in which thoughtful people can come together and really wrestle with the incredibly complicated but incredibly important questions that we can't ignore simply because they are complicated or because it's hard to know what the answers are. So with that, I just again want to thank Richard Susskind and Judge Gants and all of you who have stayed. Again, it's quite amazing. I have a little counter here. There's 750 people still on this webinar. I promise it won't be the last time. that we come to these issues, and we look forward to staying engaged with all of you as we as a profession try to wrestle with these issues, not just for the benefit of our profession, but in the name of the most noble aim of our profession, which is justice, which I think we have seen brilliantly displayed by our two core panelists. So thank you very much, and everyone stay safe. We need each and every one of you as we move through this world to create a better world to come. Thank you very much.